Hello, and welcome to another edition of Coffee Talk with attorney Brian D. Lerner. In this particular episode, I'd like to give a bit of introduction about undue influence and what it is, because it happens so often. And before you're going to bring an action in probate court regarding undue influence, you should have some basis as to what it is and some basis for how to go about recognizing the issues of undue influence. So basically, for all purposes of will contest, okay, so it's trust and will contest. So essentially, anything that deals with a will or a trust that somebody disagrees with, that's what we're talking about here. It basically means that there has been excessive persuasion that causes another person to act or refrain from acting by overcoming the person's free will and results in inequity. What does that mean? Basically, that means is that the person who either took out part of a will or trust or added part of a will or trust, that it wasn't, the bottom line, it wasn't their own doing. Somebody else essentially made them do it. Now there's different degrees of undue influence, and sometimes a great deal of undue influence starts heading towards the duress issue, which we'll talk about in another video. but basically, in order to prove undue influence, you do have to show that the person interfered with their normal, everyday thinking, and made it so that the will of the testator was subjugated to someone else's will, and that other person's will or actions essentially caused the testator to do something against their own will. So there's a lot of issues in there as to when that might occur, when it didn't occur, and so forth. And basically, proof of general influence or opportunity to influence is not enough. There, of course, needs to be more. There needs to be proof that the person who caused the undue influence, that influence was used directly to procure the instrument in one way or another, okay, either to take out or to go in. So, there's a lot of similarities between different cases as to when undue influence could arise, and these similarities sort of give you a red flag that maybe there's an undue influence issue. So for example, there are provisions in a trust or a will that are unnatural, which cut off a substantial bequests to different people. Okay, there are dispositions that are different with the decedent's intentions expressed before or after the execution of that document. There were relations that were existing between the chief beneficiaries and the decedent that afforded the chief beneficiary a lot more stuff. Okay, and then you can also see in many cases that a chief beneficiary under a will or trust was very active in procuring the execution of the instrument. So, for example, I had somebody come into my office and she was saying that so-and-so, left her $200,000 and that the whole family's fighting it. And I said, well, and at first it was, I didn't do anything, he just left it to me, type thing. And then when I start questioning her a little bit, I find out that number one, she was the caregiver, and number two, a week before he died, a week before, he had signed some paperwork saying he's going to give her the $200,000. So clearly, that smacks of undue influence. Okay, I mean, there's other facts that you have to look into, but that would just be an example of when something like that might occur. So if you are in a situation that there very well could be undue influence, give my office a call. I'll let you know. And I can work. I work on both sides. Sometimes you have every beneficiary under the sun fighting to get a piece of the pie when, in fact, there was no undue influence, but they've claimed there was. So it works both ways. So if you like the video or are interested in a free consultation, give my office a call anywhere in California. I'll be happy to help you. Give you the initial consultations free, and then we do videos once a week, give or take. So more on the coming weeks. Thank you.